We're on the final case of the docket today. That would be Kyung versus Giordano. And excuse me, Chevalier, is the appellant ready to proceed?
Yes, Your Honor.
You may.
Thank you. May it please the court, Brian Guter on behalf of the appellants, Sin Yong Kong, Lorm Sound, and Liang Bang. I would like to reserve 4 minutes for rebuttal.
You may, thank you.
The parties to this litigation entered into an enforceable settlement agreement in April of 2016. In the nearly 4.5 years since that time, the appellees have put forth a number of different arguments to justify their repudiation of the settlement agreement. This appeals the result of the appellant's efforts to enforce that settlement agreement. The appellants assert that the trial court erred in determining that no settlement agreement existed as a matter of law. And so the only question before this court is whether there was an enforceable settlement agreement between the parties. The appellee's time-limited settlement demand was sent to the appellant's liability insurer, State Farm, and it required performance of 3 conditions necessary for acceptance. First, it required payment of bodily injury liability limits. Second, it required the payment of property damages, which included payment for the total loss of Mr. Giordano's motor scooter. And third, it required an insurance disclosure pursuant to Florida's insurance disclosure statute. Now, there's no dispute that State Farm, on behalf of the appellants, sent the settlement drafts within the allotted time. A large part of this appeal centers around the disclosure that was sufficiently reliable to submit a demand, but it was insufficient, allegedly insufficient to accept that demand. And I just want to make clear that there's never been an allegation that the information in the disclosure was inaccurate or incomplete. The appellees have merely taken issue with the form of that disclosure. And so, yes,
counsel, on that, actually, let me ask. I'd like to get an answer to a preliminary question. The only letter that in the record in the appendix that I see that was signed in any way was the February 12th, 2016 letter, but only the one that appears in the appendix at page 220 attached to an exhibit to Mr. Smith's deposition. It was filed after the fact with the court. There are other versions of the February 12th letter that were not signed, and in fact, that letter that was not signed was the one that was actually authenticated through request for admission. So which letter is the actual letter that was sent and received?
Sure. Thank you, Your Honor. The letter that was filed, the signed copy that was a part of the appendix was the actual letter with the written declaration that was sent and received. The copy that was authenticated, State Farm didn't retain a signed copy, so the appellees provided that copy during the deposition of claims representative Byron Smith, and then did file that with the trial court in support of their amended motion for summary judgment. The 2 letters are identical. One is just the signed original, or I guess a copy of the signed original, and the other is an unsigned copy of that letter. But that February 12 letter, along with the enclosures that Mr. Smith described in his deposition, constitute the insurance disclosure.
And would you agree that that February 12th letter, the one that was later attached as an exhibit to Mr. Smith's deposition, is the only signed disclosure in the record?
Yes, Your Honor. It's the signed written declaration.
Okay.
And to that point, Florida's insurance disclosure statute requires a statement under oath detailing the specific information as it relates to potential coverage. It doesn't require anything more. And that's what State Farm provided in the insurance disclosure that's dated February 12, 2016, which contained a written declaration under oath pursuant to Florida law. The written declaration provided by State Farm mirrors the language in Florida statute section 92.525 and then was signed by team manager Randy Vandeman. Now, there's no dispute that a document that contains a written declaration as detailed in 92.525 is an oath. That very code section states as much. And this is consistent with a number of different cases which consider whether a written declaration is sufficient to satisfy an under oath requirement of a particular Florida statute or rule. In Harrison v. State Farm, United States District Court, in applying Florida law, determined that a written declaration was an oath. It's the same written declaration that was used here. It was an oath, and it did satisfy the under oath requirement of Florida's insurance disclosure statute. Because Harrison applied Florida law, it looked at several different cases, including the Florida Supreme Court's opinion in State v. Scheer, which acknowledged that a written declaration is an oath. Importantly, it acknowledged that a written declaration was an acceptable alternative oath to an oath administered by a notary. The third district in JSL Construction v. Levy came to the same conclusion. It recognized that a written declaration is an oath, but JSL also recognized the difference between a notarized and unnotarized oath. And importantly, JSL added that if the legislature had required or wanted a notarized oath, it would have stated as much. Again, Florida's insurance disclosure statute only requires a statement under oath. I think this case is distinguishable from the case that was recently filed by the appellees, Jackson v. State, in that Jackson v. State, the statute at issue there required more than an oath. That statute specifically referenced an affidavit. The word affidavit is nowhere in the text of Florida's insurance disclosure statute. Had the legislature, as JSL recognized, had the legislature intended there be an affidavit, they would have said as much. As it stands, the insurance disclosure statute only requires a statement under oath.
Counsel, I hate to be a stickler. Can I go back to, so we were talking about that, the signed letter, the February 12th letter, attached as an exhibit. In what capacity was Mr. Smith testifying at his deposition?
Mr. Smith was the claims representative that was assigned to this claim. He was not, it wasn't a corporate representative deposition. He was simply a fact witness as the claims representative.
So he wasn't a records custodian either, is that right?
That is correct.
Okay, so what do you read into, what significance do you read into, so in his deposition, the signed February 12th letter is presented to him as a letter, and he acknowledges that that looks like a letter, basically, I'm paraphrasing. But he wouldn't have had any personal knowledge of that. So what is the basis, or maybe it doesn't matter, but what is the basis for that deposition serving as the authentication for the signed letter?
Well, I think he testifies, it's in the record that he prepares that letter and then provides that letter to the team managers, who then review the documents that are provided with that letter, review the letter, and then sign off after reviewing that letter. The court also has the record testimony through an affidavit of the current team manager, Esther Watson, who has taken over for Mr. Vanneman, who authenticated those letters. She testified that those letters are made with in the course and scope of their job as a team manager at State Farm, or claims team manager with State Farm.
Would you acknowledge, though, just this is purely hypothetical, let's say that the letter was not signed, would you acknowledge that your argument that that was a statutory compliant letter would fail?
If the letter were not signed, then yes, I would agree with that. However, we've got, again, the testimony of Mr. Smith that the signed letter did go out, and the appellees have filed the signed letter and relied on that signed letter.
Okay, thank you.
Thank you. Moving on to the timing issue of when that disclosure was sent. Again, there's no dispute that the appellees or excuse me, that the appellant sent the February 12 insurance disclosure. The insurance disclosure satisfied the third condition of the time limited settlement demand, despite being sent before the demand. First, the appellees have stated over and over again that the time limited settlement demand was an offer to enter into a unilateral contract that could only be accepted by specific performance. However, they failed to recognize that the acceptance of this demand, which is merely the performance of the three conditions, need not be contained in a single writing. Second, unless an offeror manifests a contrary intent, the offeree who learns of an offer after he's rendered part of the performance may still accept by completing the performance. There was no contrary intent in the demand. The demand did not require another disclosure, did not require a new disclosure, or even a different disclosure. So again, the undisputed evidence is that State Farm sent an insurance disclosure pursuant to Florida's insurance disclosure statute. And we know this because, again, the appellees relied upon this demand in making, or relied upon this disclosure in making their demand. That disclosure, the February 12 disclosure, satisfied the third condition of the time limited settlement demand, to the extent that the demand can be interpreted as a request for another insurance disclosure. It is undisputed that Mr. Smith did send another copy of the disclosure on March 17, 5 days after the March 12 demand. Next,
Was that letter, but was that one signed?
It was another copy of the February 12 letter. I believe it was signed. According to his testimony, he prepared another copy of that letter, the same enclosures, and sent out the exact same thing that was sent out on February 12.
Do you think, when you read the statute 627-4137, do you read it as a claimant or plaintiff can make as many demands for the same statement as he or she would like?
I don't think there is any limit on the demand. I don't know that they would necessarily get any information. I think if a claimant has an issue with the substance or the form of the demand, and they request a new demand, it would be incumbent upon them to ask for clarification. Certainly, I think some of this case law around the insurance disclosure supports claimants asking for additional information or clarification as to a specific issue. That wasn't done in this case.
Sure, but if there is no limit on the number of times a claimant can ask for the same statement, why is there any focus on the February 12th letter? Why is the February 12th letter relevant at this point? Shouldn't it only be, shouldn't we read the demand as a separate request under 627.4137?
I don't think so, Your Honor. I think, again, except
Well, that would be an absurd result, right? That would be an absurd interpretation of the statute. The whole statutory scheme is to allow a plaintiff to determine what is the bodily limits, what is the maximum insurance coverage. Your client provided that. Surely the statute can't be read to mean that a plaintiff can ask you 10,000 times for what your insurance limits are. And if by chance you mistakenly send an unsent copy on request 933, voila, you have a bad faith action. That can't be what the statute means, does it?
No, I would agree. I think here they requested.
And in fact, right here in this case, they got exactly the information they wanted.
Exactly.
They found out the bodily limits, they found out the maximum insurance coverage, and they offered to settle for that coverage. And now here we are arguing over whether the oath is accurate.
Correct, Your Honor. And it was, you know, they did ask for another copy. They for whatever reason thought they
did. The statute doesn't authorize multiple requests, does it?
It surely does not.
And so why would we interpret that to mean you can request as many copies as you want?
Correct. Next, I briefly
want
to
we're allowed to use common sense in reading statutes?
Pardon me?
Would that be a fair rule of law? We're allowed to use common sense in reading statutes?
I believe so. In the terms ordinary meanings,
Right.
there's nothing,
I
again,
mean,
and
this
there's
exchange is not supposed to be a game, is it?
no,
Where, you know, a party asks for information, they get the information they want. There's a statement that the signer is subject to the penalties of perjury. What else is the plaintiff entitled to?
well, I think, again, in this case, they got exactly what they wanted. They got the insurance information. They obviously used that information to make their demand.
And they never argued below or even here, right? That, well, you never sent a signed copy. You never sent a signed letter.
Correct. That's never been alleged. It was, again, like I said, it was filed by the appellees in the trial court and relied upon by the appellees in the trial court.
I believe you said you were saving 4 minutes. Oh, I'm sorry. Did another judge have a question? Would you like to reserve the remainder of your time for rebuttal?
Yes, Your Honor. Thank you.
Counsel for appellee.
Good morning, Your Honors. My name is Nelson Sierra. May it please the court. And I have the pleasure of representing the appellees, Mr. Michael Giordano and Melissa Chevalier. This court should affirm the lower court's judgment for 2 reasons. Number 1, specific performance did not occur in this case. And second, the insurance disclosure sent by State Farm did not comply with Florida Statute 6274137. Turning to the first point, no settlement agreement occurred because specific performance did not occur. Your Honors, settlement agreements are governed by contract law. As this
And they're
court-
favored, right?
Yes, Your Honor.
They're
It's
favored under the law. And so your client asked for the information of the maximum insurance coverage. Your client received that information, but now the argument is that the oath was invalid?
No, Your Honor, there's more to it than that. In the March 12, 2016 demand, it specifically states that the settlement agreement or it would accept $25,000 if there is no other excess or umbrella policy.
Right,
We will, of course, need full compliance with 6274137.
right. And the insurance company told you there was no excess coverage, right?
Well, Your Honor, there's a question on that because, again, Florida Statute 6274137 specifically requests one that it needs to be under oath, and it needs to be a specific person that is authorized to make that insurance disclosure. It needs to be by a superintendent, corporate officer, or a claims manager. In this case, the letter was signed by a team manager named Randy Van Manat. However, we never knew whether or not that signature was who they say they are. We don't know if that person is even authorized to make that claim.
Do you not know that? Do you not know that now?
No, Your Honor, because even though it was signed, it was never witnessed by a third person as it is required by Florida Statute 9250.
Well, but a witness, well, and we'll get to the oath question in a moment, but I wanted to, I guess, focus in on this argument that you're now making, that the person who signed the February 12th letter was not one of the authorized people under 627.4137. How is it through discovery you were not able to ascertain, and did you put it in dispute as a matter of fact, that this person was not authorized or didn't fit one of these categories, either as a claims manager, superintendent, or a corporate officer?
Yes, Your Honor, it was stated in dispute in the lower court. It was actually one of the listed other arguments in the trial court order, that the other arguments were heard. However, this court specifically determined that as a matter of law, no settlement agreement occurred because it did not, State Farm did not follow the statutory requirements of 6274137.
So is that your argument then, counsel, that if we disagree with you on the oath, there's still other issues to be resolved below?
Yes, Your Honor. And it was listed in the reply brief that the appellants did address other arguments in their initial brief. However, a final order was only entered on the statutory requirements of 6274137. the trial court specifically stated while it heard other arguments from counsel, it declined to enter a final order on those issues. There's no final order on those issues, then this court does not have jurisdiction on those issues. But even if it determines that it does, it will still find that no settlement agreement occurred between the parties.
Well, but hold on, counsel. But so yes, it's an interesting posture of the case. So this is a non-final appeal based on a determination there wasn't an enforceable settlement agreement. But my understanding of the trial court's determination is primarily focused on that it was not an oath, or that this doesn't qualify as an oath. But is there something in the record that establishes as a matter of law that the letter, the February 12th letter, let's say, didn't comply with the statute because the wrong person signed it?
Well, Your Honor, the trial court specifically did say that a team manager still could comply, maybe as a corporate officer on following statute 6274137, but still the strict interpretation of the statute says what it says and means what it says. It specifically named who can make those authorizations, who can make those disclosures. Specifically says it needs to be done by a superintendent, a claims manager, or a corporate officer. Team manager is not listed on the statute, and if this court needs to follow strict compliance of the statute, it would find team manager does not count as someone who can make that.
But that question wasn't addressed by the judge, right?
It was addressed, Your Honor. The judge did, in the one can see in the transcript of the hearing that although the judge did say that a team manager may count as someone who can make that disclosure, I disagree, and because it does not follow strict compliance of the statute.
Right. Well,
But I mean, the order relied solely on the oath, right?
Yes, Your Honor.
so let's get to that, since that's, I think, the main legal issue here. How do you reconcile 627.4137 subsection? Excuse me. I had the wrong statute. How do you reconcile 92.525 subsection 4C? And I said subsections, actually. Paragraph 4C, but it's at the bottom of the statute. 92.525, which talks about what a document to be verified means.
Your Honor, I would point out that number one, 92.525 handles verifications, not documents under oath. Two, it states that a document can be under oath if it's done and if it's administered by a officer authorized by 92.50. The fact that 92.525 relates back to 92.50 to determine whether or not a document becomes under oath goes to show that 92.50 defines under oath, and it can get a little confusing because a document that is under oath is verified, but a document that is verified does not always mean it's under oath. And that is why that's why we are here today. And this court should take into account the 5th District Court of Appeal of Jackson versus State, that it was done on a notice of supplemental authority. While that case is discussing affidavits, 92.50 specifically addresses oaths, affidavits, and acknowledgement. In oaths, affidavits, and acknowledgements, there needs to be a proper procedure of how to make a document under oath. It needs to be witnessed by a state or federal court, state or federal clerk, or a notary public. There is no dispute that the insurance disclosure sent in this case was never done in front of a state or federal judge, state or federal clerk, or a notary public. That witness that needs to happen according to 92.50, that witness requirement, is what helps plaintiffs and anyone who can make a claim on 627-4137 know that one, the person making the disclosure is the person authorized to make the disclosure, that they followed the agreement of not only following whether or not State Farm had excess or umbrella insurance, whether or not that was the actual policy.
Well, but counsel, but that's not what a notary does. A notary is authorized to administer oaths, and that's it. So a notary is not going to verify the position of the person. They're just going to administer the oath, and all they're asserting is that they've administered the oath and the person before them has raised their right hand and sworn that the statements in that document are true.
No, Your Honor. Respectfully, the very first question for the notary is to determine the identification of that person.
Right. The person, whether the person John Smith is actually John Smith, and it's usually verified either by personal knowledge or by some identification, usually a driver's license.
Correct, Your Honor. But at least if from that identification, we can then determine whether, in this case, Randy Van Manen is who they say it is. And then we can make the determination of whether team manager even qualifies. But at least that first step of who Randy Van Manen is, we're able to once know. We never received that knowledge in this case. We literally would have to take State Farm's word for it. And that is not in compliance with Florida Statute 627-4137. And in fact, I would like to remind the court that the March 12, 2016 demand, it actually had 5 elements. Number 1, strict performance. It was a unilateral contract that must be done by strict performance. 2, it must be done within 30 days. 3, statutory insurance disclosures sent on statutory requirements of 627-4137. 4, if there is no other excess or umbrella policy, then we would be willing to settle for $25,000. And the 5th is a property damage claim of around $3,000. The appellants did not comply with the very first one, strict compliance. In fact, I would like to address Judge Tannenbaum's question of the February 12th insurance disclosures. While it was addressed whether or not there's a time limit on 627-4137, there is no time limit. However, the appellees have always done the exact same argument in saying it was the insurance disclosures did not follow Florida Statute 627-4137. It came on the question of the oath, since we never received it. Even if this court counts that February 12, 2016 insurance disclosure, it will find it did not follow the statutory requirements. And even
but the only statutory requirement that is at issue here is whether that counts as being under oath. Isn't that right?
Yes, Your Honor.
Okay, so let's on that question, just to get back to what you're distinguishing the entire statute on the basis that that only deals with verification of documents and not things under oath or via affidavit. Is that your position? Yes,
Your Honor, because Florida Statute 627-4137, it doesn't say verified. In fact, the legislature wanted to say, yes.
Go ahead, finish. I'm sorry.
If the legislature wanted to say a document that is verified, then the insurance disclosures they sent follow the statutory requirements, but the statute does not say verified. It specifically stated the words under oath in between commas. Oath is defined by Florida Statute 92.50. Following that statute 92.50, the State Farm did not follow Florida Statute 627-4137.
What would be a situation where something would be verified? What would be an example of when 92.525 would apply?
In many of the criminal cases that were cited in this case, there were probation officers that had signed a charging documents and where it discussed a verification. But there is a distinction. One, some documents could be, it's okay if it's verified. However, some documents specifically ask for under oaths. And even in cases where the courts determined while the charging document was done verified and it was not done under oath, the charging document still has to go through in front of a judge. And then when the judge signs the warrant, it becomes a document under oath. One, the document that was verified is done in front of a judge. The judge can determine whether the officer says who they say it is, and can then take the facts from the officer into account. The similar.
Counsel, may I ask you about what you consider the intent of the legislature in the statute, using the words under oath?
Under oath needs to be witnessed. Just like this court determined in Battle versus Gentry, a defined oath from the Black's Law Dictionary defining that an oath is done when it is swear to God, a person, or thing. But Florida Statute 92.50 takes it a step further and defines who can administer oaths. It's not God or thing, it's persons, but they're specific persons. Those persons are state or federal judge, state or federal clerk, or a notary public. Considering there is a statute specifically defining under oath, there needs to be strict compliance with 92.50 and not 92.525. Verified is a complete different definition. It is a different statute, and 627-4137 does not say a document that is verified. It's a document that is under oath.
So your argument is the insurance company could have easily complied with the statute by simply having it notarized?
Yes, Your Honor. If the document was notarized, then this issue would not be in here today.
Counsel, if I can bring one of my first questions to you and my last question to you together into one. When I asked about verification and under what circumstances that would be, and you talked about whether other circumstances, and this statute does 92.525 doesn't apply to oath situations. But one of my first questions to you was that subsection 4C, which actually does say the verified means that the document must be signed or executed by a person, and that the person must state under oath or affirm that the facts or matters stated or recited in the document are true or words of that import or effect. Can't we fairly read that last provision as a catch-all, and the intent of the legislature was to add to the options for doing something under oath, this alternative of doing something under penalty of perjury or declaring under penalty of perjury? Isn't that what that provision does, is to sort of, instead of going through all the statutes in the Florida statutes and amending every place where it says under oath to include declaration, didn't the legislature just put this one provision in as an option that anyone can take advantage of? Instead of doing under oath, they can do a declaration under penalty of perjury.
No, Your Honor, because even in 92.525, those words under oath is still not defined. Under oath is not defined there. And in fact, it relates back to 92.50. Using under oath, it must follow 92.50 because that is the definition of under oath, and that shows the legislative intent. Considering there is a specific statute defining what under oath is, then this court should follow 92.50 for strict compliance of 627-4137. If the statute, again, if it's asked for a document that was verified, then it would be complying with the statute, but that's not what the statute says. And this court should follow exactly what the statute says, and that is 627-4137 under oath. That definition is on Florida statute 92.50.
Can you, with the couple minutes you have remaining, can you address your alternative argument that there wasn't a settlement because of this, because State Farm asked for the title to the scooter?
Yes, Your Honor. The March 12, 2016 asked for strict compliance, and the part of the property damage claim had asked for a reasonable value of the scooter. State Farm replied, here's $25,000, here's $3,000 for the property damage claim, but we will also need the original title of the scooter, asking for those magic words, we will also. That is an additional term. An additional term is, again, part of negotiation. It is a counteroffer, and when a counteroffer occurs, no settlement agreement occurred, no contract occurred.
Actually, counsel, the demand was a bit more specific. It actually specified loss of use. It specified total loss of the scooter and summed up the amount of money for property damage that included the total loss of the scooter. So which State Farm then complied with by writing a check for that amount. What is your response to the assertion, which I think is supported by the statute, that when an insurance company declares the vehicle a total loss, they're entitled to the title? As a matter of fact, it's required that it be transferred.
May I respond? I see my time is about to expire.
Yeah.
You have some time left.
Well, in the demand, it stated that it was reasonable value, and the determination of whether or not it was a total loss, that's still in dispute. And we did provide a copy of the title to State Farm, but State Farm said, well, that's not good enough. We need the original one. But those words, we will also, that's an additional term, and that additional term counts as a counter offer. And I also like to point out that the March 12, 2016 demand requires strict performance. Sending insurance disclosures in February does not count as part of sending insurance disclosures in response to the March 12, 2016 demand. No settlement agreement occurred. This court should affirm.
Thank you, counsel. Rebuttal.
Thank you, Your Honors. I just want to start with the jurisdictional issue briefly that was raised in the FLE's reply brief. On appeal are two non-final orders which determined as a matter of law there was no settlement agreement. Those orders disposed of cross motions for summary judgment in their entirety. Although the under oath issue was the trial court's stated basis, the trial court heard arguments from counsel as to all issues addressed in the motion. Because this court should apply a de novo standard of review, I would submit that this court's not bound by the trial court's reasoning. This court is free to start anew and consider all issues that were argued below and briefed in this matter. I think that to do otherwise, to limit this case to the stated basis in the trial court's order would result in a piecemeal analysis of the sole issue as to whether or not a settlement agreement exists. It would possibly waste judicial resources and result in additional appeals. And certainly, I think it would be inconsistent with Rule 9.040, which confers jurisdiction as may be necessary for the complete determination of this cause. As to the under oath issue, this court defined what an oath is in Battle v. Gentry, and an oath is nothing more than a solemn attestation as to the truth of one's words. Those words can be written, those words can be spoken. What 92.50 does, it doesn't define an oath. It merely says this is a way you can accomplish an oath. In fact, the language in that statute says an oath may be administered by these individuals. If you look at 92.525, it says a document may be verified pursuant to 9250, pursuant to another statute, which if you read says these individuals can also administer an oath, but then it says that a document can be verified by a written declaration as detailed in the statute. By its very definition, a document that is verified is given under oath. At the heart of this appeal, again, is the February 12 insurance disclosure, which was provided by State Farm. The appellees have failed to address how they were able to rely on that disclosure in making their demand if it allegedly fails to comply with Florida's insurance disclosure statute, which was designed to give claimants complete and accurate information. I submit that.
So your argument is the February 12th letter subjected the signer to the second-degree felony penalties of perjury?
Yes, it says in 92.525 that a person who knowingly makes a false written declaration is guilty of the crime of perjury. In even the case that was cited by the appellees, Jackson v. State, it acknowledges that a person who falsifies a written declaration under 92.525, that could stand for conviction perjury. You don't have perjury without there first being an oath. the notion the notion that team managers such as Randy Vanneman are not authorized to sign the insurance disclosure statute is inconsistent with, again, the intent of the statute. You've got the affidavit testimony that says these individuals, these team.
Well, the court rejected that argument, didn't it?
No, well, yes, the court agreed.
The trial court rejected that argument.
The court agreed that the team manager was authorized to sign the.
And there's no cross appeal on that issue. You won on that point.
Correct. In terms of the timing, again, it's undisputed that an acceptance may take place before knowledge of the demand. The language of the demand did not include a different, or an additional disclosure. Judge Thomas was clear that you just get the same information over and over again. As it relates to the title, Judge Tannenbaum recognized we are obligated, State Farm was obligated to obtain that title and submit it to the state. As such, an enforceable settlement agreement exists. It was formed more than 4 years ago. The appellees are bound by the terms of their demand. The court should reverse the trial court's orders and judgment should be entered in favor of the appellants. Thank you.
Thank you both, counsel. The court is in recess.